Thank you, Mr. Chairman and members of the committee. Again, I want to thank you for allowing me to lay out House Bill 3080. Members, today individuals with severe mental illnesses can be sentenced to death. Current protections for defendants such as insanity defense, competency to stand trial, and competency to be executed once they are convicted all fail to protect the rights of individuals with severe mental illnesses at the time of offense. The United States Supreme Court has ruled our system's current protections for individuals facing capital punishment are fundamentally founded on the idea that individuals who fail to understand their actions or why they are being punished are not fit to be sentenced to death by our government. Yet, protections that currently exist for an individual living with severe mental illness do not include an exemption from execution. This legislation is important because when the Supreme Court outlawed the death penalty for juveniles and persons with intellectual disabilities, the court considered these people to be less morally culpable and determined that their diminished capacity might impact their ability to appreciate the consequences of their actions or to participate fully in their own defense. House Bill 3080 sheds light on how profoundly inconsistent it is for juveniles and people with intellectual disabilities to be ineligible for the death penalty, while offenders with severe persistent mental illnesses are held to a higher standard of culpability. If we recognize that an individual has a severe mental illness, we inherently recognize they lack the culpability to understand or appreciate the nature of their actions. The same reason our courts have outlawed the execution of juveniles and persons with intellectual disabilities. When individuals with severe mental illnesses enter the criminal justice system and are not appropriately diverted to treatment, there is a higher risk of executing an innocent person. Persons with severe mental illnesses run a higher risk of being executed, typically as a result of their bending to police pressures, firing their counsel and representing themselves, refusing to participate in their own defense, and wrongful convictions. Severely mentally ill people should not be regarded appropriately for the good of our state's communities, not executed because of inconsistent policies. House Bill 3080 also provides critical cost savings for our state and counties. The Eighth Amendment prohibits the execution of an individual who is mentally incompetent. However, the assessment as to whether a defendant is competent or incompetent to be executed occurs close to the execution date. That's after the state has paid for a death penalty trial, incarcerating the defendant on death row, and after years and sometimes decades of appeals. Together, these costs have been estimated to be as much as $2.5 million per case. We need this legislation in Texas, members. Texas criminal procedures focus on a defendant's mental state at the time of a trial or execution and do not address the issue of reduced culpability or a person's ability to understand if the act he or she committed was morally wrong. The result is a system that fails to address the fact that a defendant with a mental illness is functionally impaired in a way that disconnects his or her ability to understand the implications of their conduct. House Bill 3080 defines severe mental illness as a psychiatric illness listed in Section 1355.00 of the Insurance Code. House Bill 3080 will apply only to severe mental illnesses and not all mental illnesses. 3080 will apply to only the individuals who can prove they have a qualifying medical diagnosis such as schizophrenia, schizoaffective disorder, paranoid and other psychiatric disorders, bipolar disorders, obsessive compulsive disorders, and depression. And it's not easy to prove these illnesses. The diagnosis process is lengthy, detailed, and accurate. It is extremely difficult for someone to fake an illness that is severe. Mental health experts have estimated that only 5% to 15% of death row inmates have a qualifying severe mental illness. House Bill 3080 creates a way for the courts to assess on a case-by-case basis whether a defendant has a severe mental illness. A judge or panel of citizens will consider all of the evidence to determine whether an individual has a severe mental illness with active symptoms at the time of the crime. House Bill 3080 places the burden of proof upon the defendants, meaning a defendant must show by a preponderance of the evidence that a defendant had a severe mental illness at the time of the offense. And finally, members, House Bill 3080 exempt individuals with severe mental illnesses from receiving the death penalty. If a person is found to have a severe mental illness and is convicted, that person will receive life in prison without parole. If a person is found not to have a severe mental illness during the hearing, then the parties will move on to the trial. This bill does not allow offenders to walk free. This simply creates a procedure to appropriately manage those with severe mental illnesses within our communities. This bill allows our state to hold individuals accountable for their crimes. If a defendant qualifies for the exemption, they will still be subject to the criminal prosecution. With that, members, I will be happy to answer any question, and I reserve my right to close.
Any questions, members? Thank you very much. We'll call you up to close.
Thank you.